meeting is being recorded.
Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote awareness of mediation in the world around us and to talk about mediation from the perspective of a common person. We continue with a short legal disclaimer. The views expressed herein are the voluntary personal perspectives of the speakers and may or may not represent the views of the larger professional community they belong to. The conversation series aims to provide a general overview and awareness of the subject matter involved and may not be construed as a legal or professional advice in any manner whatsoever. This session is being recorded for wide circulation. Let me introduce the main speaker and the guest panelist for today's session on the practice of mediation. We have Ms. Kathleen Ruan Leedy. Kathleen is a bi-coastal mediator trained and has a diverse mediation career with over 12 years and has mediated over 1,000 cases in court and private practice with an above 95% settlement rate. And that's really too good, Kathleen. Kathleen has been the coach and training coordinator in the mediation department at Family Services of Central Massachusetts, training mediators and developing programs. She is listed as an open meetings mediator for Attorney General's office in Boston. Kathleen was selected to author one chapter on mediation in a book about divorce titled Worry Free Divorce, Leading Divorce Professionals Speak. She has coached and judged mediation tournaments for the International Academy for Dispute Resolution International Mediation Law School. Kathleen has facilitated the 40-hour basic mediation class at Drake University Law School with Dick Callens in Des Moines. We welcome you on board, Kathleen. It's a pleasure to have you with us.
Thank you so much.
We have as guest panelist Ms. Ujjwala Gupta, an advocate having a proven track record of successfully and efficiently delivering a wide spectrum of legal services. Ujjwala is an experienced individual with a demonstrated history of handling corporate advisory and regulatory framework alongside white-collar and corporate litigation, extensive policy advisory, comprehensive constitutional and administrative cases. While practicing across high courts and tribunals, Ujjwala has sailed through her clients' legal challenges, litigating issues pertaining to government tenders, administrative and service laws, amicable settlements, and anti-competitive practices. Welcome on board, Ujjwala. It's a pleasure to have you here.
Thank you so much, Sonal. I am thrilled to be here.
We also have today Miss Mansi. Mansi is a penultimate student at WIPS IP University. Now you'd have to tell me what that means, okay? I'm not aware. She is a trained mediator with strong interest in mediation and is passionate about finding peaceful and collaborative solutions to conflicts. Welcome on board, Mansi. It's a pleasure to have you here.
Thank you so much, ma'am. It's a pleasure of mine as well.
You can call me Sonal. So, Kathleen, you have such a diverse, experience ranging from being a trainer to a mediator with 95% of settlement rate, and in mediation, that means a lot. So, let's talk about what, in your opinion, is mediation, and especially from the common person's perspective, mediation in civil matters, in matters which may not, because family mediation has almost been covered by most of the people. But what is civil mediation like in civil matters, in cases? The floor is all yours, Kathleen, please.
Thank you so much. And that settlement rate that you mentioned, and what that settlement rate really means is that people got to walk more successfully into their life. What we did at the mediation table made a different future for them, a new future forward with different decisions, new understandings, which I think that mediation is about success for people. The variations of success that we see at the mediation table, one of them is an agreement that people can actually live and walk out in their real lives after they leave the mediation table. Another success in the mediation is the clarity of information and the accuracy of information. Another success at the mediation table is understanding the emotional tenor and letting people express the emotional tenors and making that safe environment that we promised in the beginning of our neutrality. Therefore, we are a safe person to have in this process as a standing neutral at the mediation table. And these beautiful principles of mediation are practiced across the world. I see the practice of mediation as our job to get better and better and grow, and our competency should be rising with our process. Hence, people get to have new lives. So there's my passion. Mediation, both in the courts where I practice, civil and also private practice, is a beautiful process because the courts are asking people to mediate, or people have the option to mediate their cases in court, where they can have that fully empowered conversation, make their decisions, and walk out. I was mentioning yesterday in Washington State as well, people can dismiss their cases at the mediation table in court and walk away with no more future litigation between them or a mediated agreement because it's been dismissed. Counterclaims can be dismissed. There's a lot of beauty in the mediation process within the civil process in courts. And a skilled, competent mediator will guide the parties through all of their options, exploring everything, even allowing those emotional tenors to be explored at the mediation table, and not be tentative or timid about people bringing the culture of themselves to the mediation table. The neutrality, as I see it in these civil, cases, whether I'm in court or private practice, is the fact that people get to be themselves at the mediation table. They don't have to change it up. They can be themselves, and it's our job as a standing neutral at the table to manage all of everything that's coming to the table: information, emotions, and the culture of the different cultures of the people that are at the table. In my private practice, it's the same. Court is less time, of course, with people. Private practice can go on for weeks and weeks, 7 months, a year and a half, 2 years, which is more of a relationship. So the part of mediation where we bond with our parties is very important, of either our process in court, quickly bonding and establishing trust and rapport, or in private practice, bonding on and finding more and more out about our parties. At the end of the day, we as mediators, we are in the peacemaking business. And we are trying to establish, help people understand that they can have new peace between them, capture the old peace, keep the new peace, create peace. And we invite meaning at the mediation table. We're preserving meaning all the way through the mediation, and we're establishing and creating meaning at the mediation table. So this is all about meaning. And I also see mediation covering every possible scenario in life. For instance, 2 years ago, I did a medical mediation that everyone told me not to do with a gentleman that was bipolar, and everyone told me not to do it. And he had been in counseling for years and years and years, and all these prescriptions. And it was the clarity of mediation and chasing the accuracy of mediation at the mediation table that gave this gentleman a whole new life. He put his world, back together, and is now successfully rejoined with his life that he loved and cherished, and more accountable for his decisions and choices that led him down the path of creating chaos within his own life. And recently, I just finished a mediation that was about a coffee table book, where the book publishing contracts lacked clarity, lacked accuracy. And as a mediator, we have these skills to look at what we see contract-wise, just like looking at court documents and trying to understand them. And we can see what this doesn't make sense. We have the clarity of saying, this seems like there's a gap. This is a gray area. We need to nail this down tight with contracts, just like we nail it down tight with people's agreements about how are you going to live this out, what, when, where, how, all of that we put into agreement writing as we draft can be applied to looking at other people's contracts and seeing the gaps. So I literally, the whole range, Sonal, of like medical mediation to coffee table book, from a country in Italy to the United States in Maine to then to the United States in California. Mediation took all of those pieces of information and people and brought them to a Zoom mediation table. So that's kind of how I see it roughly. That's a couple of little stories that I have, and I'm looking so much forward to hearing what else is going to be said here today at our wonderful conversation. And it's a pleasure to be here with all three of you.
Yes, that was really a good description of what you do and what mediation actually, you know, when you talk about medical mediation, coffee book, table book, and all. So let's ask Ujjwala here. Ujjwala, when you are litigating, uh, from filing of a matter to the final order, you know, it takes a lot. It's a journey, right, for a litigator also, and for the client also. So when we talk about mediation, we talk about emotions, we talk about relationships. When we talk about litigation, we talk about the right and the wrong, the the monetary benefit involved, the who has been wronged and what needs to be done to make it, you know, to justice, to deliver justice. So what difference or what litigation is about? Let's talk from the perspective of a common person to understand what mediation vis-a-vis litigation would mean from your perspective as a litigator.
Right, absolutely. Thank you for the question, Sonal. So when we talk about laws, so what laws are, exactly? So laws, I believe, are certain rules and regulations that the statute or the state has kind of, enshrined upon us, which kind of set certain boundaries. Within those boundaries, I, as an individual, have to ensure that I do not cross those boundaries and do not hamper or jeopardize the rights of another individual. So I think when the state or when the laws get involved, what really happens is that the primary objective is to provide or to protect the inter se rights and responsibilities of two separate individuals. However, when we talk about mediation, I feel there's a personal touch involved. When I am appearing for a client, what I really would, be mindful of is the fact that I do not cross boundaries of the law. I think, be a little more less concerned with respect to what my client actually wants. I would be far more concerned that he or she doesn't crosses a boundary. So I think that is one of the key differences. Also, I feel when we talk about litigation, when we talk about hardcore litigation, I feel there are so many numerous stages, which an individual has to follow, like starting from, putting in a wakalatnama or maybe a representation wherein you take the responsibility of representing that client. That is one, of course, is the stage. Then you go ahead, you mention that, all right, these are the n number of disputes that my client or I as an individual am facing. Then we kind of, intend to highlight, all right, this is how I have been affected, or these are the possible reasons owing to which I have suffered so many number of losses and all. And then I think I leave that forward with a judge who is apparently listening to me or to my matter. And then it, of course, lays in the hands of that particular individual, how that individual perceives it. And then, of course, the decision is given. So this process, I think, kind of takes so many number of years. So I think the help or the aid or the advice that I think I particularly needed at that particular point of time, I feel that time is lost. And when that time is lost, I feel, the kind of help that I would have received at that particular point of time is also lost. But when we talk about mediation, I feel I, as an individual, am in a better position to kind of, put forward my claims, kind of able to justify how exactly I am the sufferer. And of course, there's a personal touch involved. So I feel that, of course, not only saves the time and energy, that also saves a lot of money. I think it also kind of creates a safe boundaries for the individuals or the parties that are involved. However, that is not the case in litigation, or in cases, because what really happens in cases, that we kind of place reliance on the past judgments or the past situations that we have encountered. However, my matter is my very own when we talk about mediation. And I think when we talk about arbitration or the alternate dispute resolutions, so I think there's one very important factor that I would want to highlight is that it is a time-bound matter. When we talk about arbitration, so arbitration is for an year's time, which again can be extended for another 6 months' time, making it a total of, so to say, around 18 months' time also. However, that is not the case with litigation. So litigation can go on from years and years. So, this is very one interesting incident that have happened with me. I apparently took up a matter of a client who is suffering. That's a property dispute. So now, when I realized, when the files came in from some other lawyer to me, I realized that that particular matter was filed in back in year 1992. So, it pains my heart to see how litigation from the year 1992 have been dragged till 2023, and yet the parties are still suffering. However, of course, with respect to mediation, I think it's, the parties are kind of, the intent of, parties going ahead with mediation is to settle the dispute at the earliest and to come out with best possible outcomes. Of course, there can be situations when that doesn't really happen, but I think one absolutely needs to try. So that is, I think, how I would differentiate between litigation and mediation.
That was really wonderful, and a clear perspective of what a litigation actually means. It shouldn't have been like that is also one thing that I would say, that, you know, because litigation is as much needed as a pillar of a country's, judicial system as mediation or
Absolutely.
alternative dispute resolutions are. But here, let's talk to Mansi. Mansi, what are your views on this? You're a student and a mediator, the law student and a mediator. So you're going to that area where we already are, either Ajula in the litigation or me and Kathleen, and of course you also now a trained mediator. So tell us, what is your opinion about this?
Okay, so I have realized that there are multiple areas where mediation can be applied, be it consumer disputes or family mediations, like you guys uh, actually practice. But the problem I have seen in multiple cases is that if we specifically talk about India, people are not aware of their rights. They are not aware that they can mediate legally as well, and it can be done in presence of the court's order. It can be court annexed, or it can be an in-house mediation.
Yeah.
In multiple companies, when we talk about employment mediations, then what happens is the in-house counsels that are actually sitting there for mediation are not very well trained. So they somehow sort of get biased, and they have an inclined interest towards one party, which actually just disrupts the whole intention behind mediation. It is supposed to be neutral and unbiased. And when we talk about family mediations, then there's a lot of chaos when we talk about it. You guys already know it. So the problem that I see is that people are not aware that who should they actually pick as their mediator. Like, they should consider what the fees is being charged, the skills of the mediator, and the working style. For instance, I could be comfortable with Kathleen ma'am,
Yes.
but I am not very sure about the other mediator that I have been appointed with. So
Yeah.
what I can do is I can pair up with her and work towards that cause. So in order to get the actual results which are required. So I think people need to understand that they can pair up to advance the cause and not to, just mess it up, or you maybe just bring it to something that would only benefit their interest. Because when we talk about fees, the person is getting paid, getting the fees paid. However, the cause is not that we need to finance ourselves. The cause is that we need to resolve their problems without any further issues. So I think that is one thing that I would really want to work in the area of, or if I can get an opportunity, I would like to see that thing happening. Like, people should know that how can they appoint their mediators and get their disputes resolved without even pursuing the option of the court.
Yes.
Or if they're actually going to the court, then they can get it court next.
Yes. So that awareness part is really very important, because that's how, and especially when we're talking about India, the law coming up, the rate of awareness that, I can get this thing, this dispute, in this way, where I do not have to spend a lot of time in the court. But here we should talk to Kathleen also. Kathleen, what is the idea of uh, lawyers being present, because that is also important in civil matters, because a mediator might not be aware of the legal nuances, the financial nuances, because if it's a corporate lawyer being present in mediation, they can guide their, because as such, mediators are obviously not allowed to, give their opinion. So, what do you think about the lawyer's role in mediation, especially
I
in civil matters? Yeah.
I absolutely love counsel at my mediation table.
Yes.
The downside of mediation, as I see it, is the fact that people may lose their rights at the mediation table when they draft an agreement. And so, first of all, the awareness, this is your right and you're giving it up, or you're partially giving it up, is really important. And lawyers can protect those rights.
Yes.
And lawyers can listen to the mediator and the parties as the parties agree to compromise those rights a bit for a fully empowered agreement as they see it for their personal lives. So, for example, in Massachusetts, the state of Massachusetts will often forego the normal child support payment, will downward deviate it to lesser amount, because the person's going to do something else for that child, even though that right belongs to the child. But at that mediation table, parents need to understand child support isn't their right, it's the child's right to have those monies. So I see the danger of mediated agreements being agreed to by parties that don't understand their rights. Like landlord-tenant in the United States, when you have a lease with a landlord and you don't pay your monthly lease and the landlord brings you to court, your monthly rent, and the landlord brings you to court, and you pay the rent, which is the remedy in the United States, then the landlord wants to break the lease and move you over to a month-to-month only tenant. No, you're giving away a right if that would happen. So the sharing of information at the mediation table and asking the attorney, what does this look like? How does this impact this mediation? Attorneys are always willing to do that. And I also love having attorneys at the table because they're always willing to draft for me and with me. And I will ask counsel, please start drafting. And then mediation, the common language combined with the legal ease, can be a very good document. The problem with counsel at the table, when I do settlement conferences a lot over in Washington State, is the fact that sometimes when the court says you have to go to mediation, you have to keep a mediation appointment before you can come to court, mandatory mediation appointments, as they really are, is the fact that the mediation can take a turn toward what the parties want, but it actually crosses velvet swords with counsel's process and strategy for court. And I because the clarity of mediation, I've literally had counsel tell me, have had counsel tell me, Kathleen, I can't have my client agree to this because that messes up with my court strategy. And the mediation table needs to respect that clarity as well. And then counsel and client now get to decide which way they want to go. And because counsel is actually representing the client, most clients will follow their lawyer's lead, even at the mediation table. So this is kind of the interesting dance as I see it: mediation, counsel, agreement writing, strategy in court versus a fully empowered conversation of parties at the mediation table.
Kathleen, you have actually summed up the whole world, or what is a global problem people are actually facing, because there is both the parties are doing their work, and they're doing their work diligently. But the problem here is that first, both of them need each other also. Let's face it, because if we want more cases to come to litigation, then we should be able to process them faster also. And mediation is a way where, cases which do not involve the question of law, as Ujjwala, you will also agree to it, that, no merits are involved. Only there is some technical dispute about, say, I will call it a negotiation dispute about facts and figures and numbers that is happening, that Kathleen told, the legal dance is also happening. That is where a litigator is most required, where on the table. So as Kathleen also puts it, it is very important for to have in the mediation table, on the mediation table, a good both the parties being represented by their attorneys. But here lies there's this problem that nobody could so simply put out, that yes, the I would say, the process, as you call it, the process of litigation takes a little different because the ideology is different. Here we are talking about, peaceful resolution, and we are looking at the future. But litigation has to look at the wrong and the right. It, whether it is a suitable option is there to, a little deviation is required. But then here the process and the ideology of litigation is in a clash. So Ujjwala, what are your views on that?
Well, I do second with what Kathleen had to say. But again, like you rightly mentioned, when there's a question of law which is involved, or maybe when there is public interest which is involved, like I would sum it up with an example, because I apparently was undertaking a mediation quite a few months ago, wherein there were two parties involved: one the developer and one the landowner. So the basic crux of the story was that the landowner kind of gave up or maybe entered into an agreement with the developers. So they apparently had to, develop a building. It was more like a real estate project wherein they had to come up with a four-story building, which was supposed to have some 200 apartments and so on and so forth. So the parties agreed, they came into an agreement. So this project was supposed to be complied or be completed within a period of 2 years' time. Unfortunately, that could not happen. And of course, it did jeopardize the home buyer's interest as well. So I feel, in situations like these, when the public interest at large is involved, I think it is really imperative that, such imperative points are taken up, and, it is seen in such a manner that the public interest is not hampered.
Yes, definitely. That, that the larger interest of people cannot be compromised on a mediation table. That's what. Yes, definitely. So, Mansi, what are your views on that? No.
Adding to what's already being said, I feel that the agreements that are being drafted should not be confusing. They should be very clear as to what needs to be done by whom, at what time, during what period, and all the chaos should be cleared out by drafting the agreement. It should have plain language. It should have, bits and pieces of legal language, but it should be clear in what the agreement actually is all about. It should be like it should specify the dates, address the people by full name. Like at times it should be an active voice. Like if you're using passive voice, then him, by her, by them, that can be confusing. So it should be an active voice, like what needs to be done by which party. And in case of the violation of the mediation agreement, what can be done? Like that would create a legal obligation on the parties, and at the same time make them comfortable with actually fulfilling their obligations.
Yes, non-ambiguity of the legal document is very much necessary, and for that, I think the legal representation on the mediation table is also very necessary. We all have been talking about mediation a lot, but the role of an advocate in mediation is also, like Kathleen pointed out, it is very important because it gives a confidence to the mediator also, that legal points are being handled and they are being taken care of. The agreement that is being signed, because you can talk, you can negotiate, you can talk about the facts and the figures, and a verbal agreement is reached. But when you come to drafting and when it has to be implemented and it has to go a long way to give it an executionary status, then I think the legal body or the lawyers being present is a real relief for all mediators also. That's and especially for, I think, Kathleen will also agree, to civil matters, because there are the chances of going back on when words are concerned. And there have been cases where tax was also involved, tax evasion, because a common person will not know where I am going wrong in tax evasion, where things are going uh, beyond the legal ambit of uh, or the legal scope. So that would really make a lot of difference. So
And if
that,
I may add,
yes.
if I may add, we could have a whole program on agreements, because agreements are alive. They're breathable as well. So we're not only pragmatic. Mediation is a process of pragmatic and intuition and freedom. And the agreements oftentimes reflect the same things. So, for example, very pragmatic agreement would have all the W's, what, when, where, why. What's the consequence if it doesn't happen? So that's very pragmatic, and it's very law-like. And that's important for every river needs its banks. Every agreement needs its banks, right? So we've got structure with the agreement. But then agreements can need also sometimes to be breathable. For instance, what do we really want with an agreement? We want the parties to be able to interact with each other. Well, some of the parties are interacting with each other because the agreement's telling them what to do. Well, what's the greater peacemaking opportunity? Sometimes I write an agreement. If this happens, parties agree to discuss with each other by telephone, by email. Parties agree to have a fruitful discussion, which now puts them out having a discussion to see if they can learn from the mediation table and have a discussion amongst themselves. And that's real confidence. Yeah. When they model the mediation process, or the mediator, which happens at the table oftentimes as well, and they do it in their real life outside the mediation table room, that's progress, that's confidence, that's growth. So in my mediation table, I'm always expressing gratitude. Thank you very much for that agreement. Thank you for that suggestion. Monzi knows, I trained Monzi this way to do that. Well, then people start thanking each other at my mediation table. I'm smiling, I'm laughing inside myself, because that's growth. Because as mediators, we're also educating. And what are we educating? We're educating, we're skill educating, giving people new options of how to talk to each other. Yes. So our agreements need to be breathable, as well as have rigidity, have structure. We could have a whole thing on agreements. I think that would be a great show. I don't know if anyone's ever done that, but it's such a subject of focus in my mind, because we're talking about agreement rates and how mediators really don't contribute to the agreement rates. It's really between the parties. We have all this philosophical discussion around these agreements that we're writing, whether they're binding or a memorandum of understandings. And we're not really looking at what an agreement actually is for the people at the table. And who is the most important person at the table? I always say, Monzi knows this as well, it's the mediator, because we're conducting the process. So I think our agreements are only going to be as good as what we are able to help the parties agree to as well. And we don't make that link oftentimes. And I've literally been in a mediation center out on the West Coast where parties left that mediation, another mediation said, we can't even mediate right, as they are walking into the elevator, because people expect to be able to do something in a mediation, to get something accomplished, because they are encouraged to share their voice and to share their story. So therefore, maybe with another person there, we can work our way through this conflict. So mediation is so important on so many levels we don't even talk about.
I would want to add something, a very little to it. I mean, I completely agree with what Kathleen had to say. So there's a very interesting bit that I have lately experienced, which is I feel that everything that we do, every task that we undertake is for the attainment of a primary objective, which we have in mind. Say, for example, two parties are entering into a project or maybe an agreement. So they are entering into that agreement for the attainment of whatever project that they are going ahead with. So like, Kathleen mentioned that the agreements have to be breathable. So there's a very important suggestion that my superior gave me the other day, which was I was drafting a lease agreement and I mentioned that if at all there's a breach, the parties would directly, refer the matter into mediation. But before that, my superior, highlighted and he gave me a very important piece of advice wherein he said that instead of directly, referring the matter to arbitration, you could give 30 days time to the parties to meet, to talk and to figure it out. And then if at all it doesn't work, then they can of course go to mediation. So I think that's precisely what Kathleen wanted to, highlight. And I completely second to it. I think that's a beautiful piece of advice, teaching parties to kind of, accommodate each other and to kind of welcome each other with open arms, with the sole intent that the attainment of the objective is far more important than anything else.
Wonderfully said, wonderfully said. Because yes, because if two people have to come to the mediation table, they have to have a consensus of coming there. That the purpose of mediating is that they both want to move in one direction and they both are agreeing to that direction first and the foremost thing. Because after coming there, when they will be moving towards that direction, they should be aware of what they are getting into. Most of the people, like Mansi also said, are not aware of what they want, because that litigation channel has always been there and that has always been the only one option that has been known to people. So obviously people would have, thought of going towards that direction only. That's, that's where we really want that people, when the law is also coming up in India especially, and people are gearing up for mediation or alternative dispute resolution solutions. From what you told, Ujjwala, that means negotiation actually. Negotiate first of all and then go to the next step. And if that is also not possible, then move towards litigation, because that involves a lot of energy, time, and money. And yes, then relationships. Let's talk about relationships, because that is very important. Because in business also, well, in family, yes, in business also, relationship matter a lot. Because if I have a problem and I have taken you to court. Now, how are we going to work in the same business? Are we going to move ahead? Kathleen, that aspect, I think, for a common person's perspective, we should touch upon that also, the relationship part.
Exactly, because let's really talk about it. The real family court, people can divorce each other, and if they don't have children, they can go to they go. If they have children, they have to intersect with their children. Business partners with commercial mediations, they're stuck with each other unless they collapse the business. So it's even the more factor of how do they feel as they're making these decisions at the mediation table. What does it feel like? Because agreements have a feeling to them too, at some tenor level, somewhere from a 1 to a 10. Agreements have to feel good at some level, not just be pragmatically astute, but also have a feeling associated with it. So people that are stuck together, it's even more important to address the relationship. Do you want to preserve it the same way? Do you want to less preserve the relationship? Do you want to have the more, now that we've been through mediation, there's more clarity and accuracy at the table of how you feel about each other? The back dealing or whatever it is, so they get to determine the relationship. That's why studying the 5 apologies is so important as a mediator. You can have a social apology to each other at the business table saying, you know what, we don't admit any responsibility, but we are sorry the situation happened and let's move forward with a clean slate. So
Wonderful.
all of this comes to the competency and experience of the mediator. And that's why Manzi's right, we need each other. We need to all sit down together and have this flow in our practice where I have interns with me, people that are practicing in other situations in India have interns with them. And, you know, my thing, Manzi knows about India, and so do you, Sonal, is that our law schools in India need to have mediation centers, clinics in them, where students are mediating the real cases from the court, civil cases in their state, starting year 2, and by the time they get to year 5 or 4, they're experienced mediators, they're certified, and they have a business that they could go out and do before maybe they actually even start lawyering. But more importantly, the 55 billion, I think, case backlog in India, every law school takes bites out of it. Every law school across the whole country is mediating down this tremendous burden that your country's under, where justice is delayed, as Manzi and Yuala mentioned.
Wonderfully said, because that really needs for our country, and that's one of the practical and pragmatic solutions that you've talked about. And also, when we were talking about relationship, Ujjwala, you can also put in, and we'll ask Mansi also, when disputes come out in open market and it is being handled in the court, the goodwill and the reputation, that's where, you know, because if it's a family, you can understand that it's a family dispute, maybe they go both part ways, like Kathleen also said. But when it comes to business and when goodwill is involved, when how important it means, the preservation of a relationship, and when it comes to litigation, how important it is for every party to, you know, there's a pressure on the mind to come out clean out of it. Because when you are coming out clean out of it, that means your relationship or your reputation and goodwill in the market is restored, and you have enough, because it's business and you really need your goodwill. So let's have your viewpoint on it, because when a case comes, what is the pressure, because this also affects the lawyer, what is the pressure on a lawyer to, you know, come out clean for the client to win the case, so that it's a goodwill matter for them.
Right, that's a very interesting question, Sonal, I would say. So, you know, when we talk about any dispute, I think it's really important that when the dispute is at the very nascent stage, or when in an initial beginning, the same is referred to mediation, because that will not only save me or would enable me for safeguarding my own reputation or maybe my company's reputation, but also will allow the same thing to the other party as well. But you know, of course, there are unfortunate events when the same doesn't really work out well for other organizations, and the parties have to kind of take it ahead in the courts. So I think there's a lot of pressure involved on both the parties and of course on the lawyers as well. Parties do waste a lot of money, a lot of time, a lot of energy in not only kind of protecting their rights or their liabilities that are arising out of the dispute, but also their reputation as well. Because I again would, simplify this with an example. So one of my client, he belongs to an IT organization, IT company, and he was kind of, undertaking development of certain software for the opposite party. So I understand that, of course, my client at some point or the another had kind of lacked that professional skill, owing to which the dispute arose. But then again, my client was constrained to go ahead with the litigation only to safeguard his reputation in the market. So I think, these are the kind of things which, again, like Kathleen or you would say, would in fact rightly point out that these are the kind of things that we can safeguard by either mediation or arbitration, because again, those are the kind of things which are confidential in nature. So I think that really helps a lot. Also, when we talk about, personal matters, when we talk about families, I think that there's a quote that I believe in, which is hope. So hope is a beautiful thing, and of course, the most dangerous things of all. So I think, a friend of mine is undergoing a divorce at the moment. So not only is it painful for her, but for the family as well. But I think there's a hope that is lost, the hope to restore the relationship that she had built with her partner. So I think once the matter reaches to the court, people kind of say that now that you have approached the court, now that you have moved so forward with this, why on earth would you want to go back? So, when parties enter into litigation, they kind of, miss on to certain opportunities to restore what they once really cherished. But when the parties are in mediation, the mediator at the table, his or her intent, of course, is to safeguard what is really important to the parties. So, the parties might openly accuse each other in front of the mediator of all the wrongs that have been committed. But again, when they come back home, they still have this hope of working things out. So, like, Kathleen must have mentioned, like, about relationships. I think there's this closure that we all need. So I think that's something that we apparently can go ahead or can definitely get in mediation, which of course we might not get into litigation. But then again, there are, times when so much is at stake, when the company's values or, is, running in crores and crores of turnover. So at that point of time, what really is important is not the loss that a party is suffering, but of course, I think the goodwill that is at stake. So I think, it really depends on situation to situation. But yes, I think the facts and figures really do come into play at these particular points.
Wonderfully said. Facts and figures come to play. And yes, Mansi, let's hear your perspective also.
Okay, so what I have learned during my training is when the mediation is going on, the mediator needs to notice the parties, which is one of the major rules. Like, you have to notice the parties, and if they're repeating a word twice, you just let it slide. But if they're going thrice and they're constantly repeating it, then you have to address it. Like, you have said this thing quite often. Do you need to talk about it before we start with the next thing, or do you want to address it right now, or do you want to address it at later some point? Because that thing is the most important thing to that person at that point of time. And without it being addressed, the person would not be really into, moving forward with the next thing. So that is one thing that we as mediators should notice. The other thing that I have seen is that while the councils are there to support their own client, but there are there are councils that also are looking forward to an end to the matter through mediation. However, there are times when the councils overpower the clients. They're constantly trying to get the matter to litigation. So in that scenario, the mediator needs to calm down the council in order to actually save the relationship that is on the mediation table. Because when we are actually listening to somebody, because the person who's there at the mediation table is already going through an emotional turmoil, I believe.
Yes.
And if somebody is constantly adding on to it, like, yes, you're suffering through it, yes, it's happening, I think you should go to litigation, mediation is not working out for you, then they'll be hyped. Like, yes, the person is saying the right thing. I have suffered through this. I should go to litigation. Why should I compromise with this person? This person is doing wrong to me. But if the mediator gets hold on to that thing, the client would actually be a bit calm and would um, actually address to the whole thing. One more thing that I have seen and learned is that when a person is crying, you do not offer the tissue. You let the person just feel those emotions and get through that process by themselves. You don't break the flow by offering the tissue, or you need to calm down, or even calming them down. Like, just let them speak whatever they have in their mind or in their heart. Only then will the mediation process go forward with the intent to actually give it a closure to even the client and to the whole process.
Yes, that's really nicely said, because the closure, as Jula also talked about, the closure is very much necessary, because whether it's litigation or we are on the mediation table, the closure needs to be done on things that have been apparently seen also, and there are things that are happening which are apparently not visible to the eye. Kathleen will also agree to that, because
Yes,
yeah,
absolutely. And this is the magic of mediation. This is the hard work of mediation, but it's also the beauty of mediation, because we start off in mediation with issues that are typically written down on paper, on documents. But all the way through that mediation, there's a meta, there's an emotional tenor, and we end up mediating the moments all through the mediation. We end up mediating moments like what Mansi just described. You all just described. These moments, we have to clarify and chase accuracy in the moments as well. So we've got these organic moments that we didn't know were coming, usually with an emotional tenor attached to the words. So it's very meaningful to these people. We have to mediate that moment, and we've got to hold the space for parties at the table, but also hold our own space. That's why Mansi can sit there and let someone cry and not offer tissues, because Mansi is holding her own space. And she also knows, because of neuroscience, that there is a hormone that's released that brings relief when people cry, especially women. Mansi knows that neuroscience. So she's got the skill set to hold the space for the person at the mediation table that's crying. And she's going to wait and hold space because she's mediating that moment in such a beautiful way.
yes, and yes, there is a difference. When you were speaking, I was also thinking that there is a difference between both the roles of a litigator and a mediator, and both are actually needed for a country's progress. When we are talking about mediation process, we actually need litigants to explain why it is necessary for the parties to go through mediation, because here there is a role of a litigator also, who actually guides them through the legal process, because when a mediator is involved in the emotions, is involved in preserving the relationship, the litigator's main aim and purpose is to see that laws are not compromised, because that would make a lot of difference. That would be rape of whatever is happening. I mean, that word is not to be used, but yes, that would be apparent injustice. So to see that, everybody has as a team, you will have. I mean, people will have to work, because there is something that is happening, and the emotions apart, the relationship preserving apart, the legal aspect also needs to be seen, that no injustice is being done to anybody. Like Kathleen, you also said in the initial part only that that's very much necessary to see that that should not happen. So, any closing comments, anybody? Because it was a good session, I should say. We have actually touched upon every aspect from a common person's perspective to make people understand the need for mediation and why things are being pushed to mediation table to preserve the relationship, which is very much necessary. And yes, the litigant's role is also very pronounced. We might not understand it right now at this moment, but when things will come to the mediation table and things practically come, uh, we really need someone to be, on the guard, always looking at what the laws are, what the legal status is, and why and how things can move to a direction of amicable solutions, yet preserving the legal sanctity of that is very much necessary. Any closing comments, Kathleen? You.
I guess I would add, in some states in the US, mediation is very much cherished because legal mediated agreements can't be appealed. So, a decision in the court can be appealed typically, depending upon the rules of the state, the claimant, the defendant, plaintiff, the defendant. So that the huge confidentiality in mediation, where mediators keep 100% everything confidential, parties are 0% confidentiality unless they want to write it into their agreement. Then the extra layer of confidentiality, where if you don't want us to repeat it to the other side, we're gonna keep that confidential as well. So I think the confidentiality of mediation, as I stumble over the word now twice, is a huge draw and a huge beautiful part of this process. I believe the panchayat, if I'm saying that right, the tradition in India, those cases are even in front of the village, people in the village.
Yeah.
So the confidentiality of mediation is really, really special and brilliant from the founders of the process. That's how I would end up this lovely conversation. Thank you for this platform. You've covered everything that is passionate in my heart, and it's been lovely to hear what everyone else has to say as well. Thank you.
Yes. And that brings us to, yes, you rightly pointed out, Kathleen, that, on the table, the confidentiality, and yes, the preserving of the relationship, and where the litigant's role also comes up. Lovely. And yes, we need both hand in hand, mediators and litigators, because ultimately we are helping the court process only. We both, if we join hands, it's helping the clients as well as the court process as well as the country's legal system. That's all I can say. Any comments by lovely ladies?
No, I mean, I completely second with you. Of course, they are indeed two parallel lines going ahead in the same direction. But I think, it's time that we as individuals, strive forward to kind of, encourage the role of mediators and mediation at large, rather than, going ahead with, litigation per se, maximum of the times. Because, I myself, being a litigator, thoroughly enjoy litigation. But again, at the same time, I also, as a human, understand that, safeguarding what is really important is the primary objective. So I think that really is the objective here. So yes, I mean, that was such a fruitful conversation the four of us have, and I was so thrilled. And wow, I feel on the top of the world. That's how I will summarize it. Thank you so much, all of you. Means a lot.
All pleasure, all pleasure. Mansi, anything from your side? And we close it up.
This was such a great session. Definitely a lot of insights from all of us. And then the best part was that we didn't only discuss about the mediation aspect, but we kept litigation hand in hand. So that was more something new that I have seen today. It was a very great session. Thank you.
Lovely. And thank you, everyone, for your contributions. May this message go to the world that if we have to move ahead, especially for the clients, for the legal system, for the country, then litigants and mediators have to move hand in hand. Thank you so much.